million or so. And whether you have few competitors, if you have lots and lots of people competing, lots of people now competing in this referral business, using the social media to refer people. I ate dinner at this restaurant and I send broadcast to all my friends that they know that this restaurant where I enjoy it, so this restaurant get more sales and so on. So if you have lots of competitors, it's so difficult to sort of make headway, but if you have few, then you have a better chance of succeeding. You also have freedom to operate. I'm going to hear from Eric about the freedom to operate and how sort of in terms of patent that you have nothing, nobody's blocking you in terms of right to use. That it is economically viable, and so you have the sort of the whole solution is viable, not only part of it. And most important, of course, that you have a motivated and qualified team that's ready to put their heart and soul into it, and with a passion, because you're going to meet lots and lots of difficulty along the way. And someday you're going to wake up and you don't want to get out of bed. And then, but only the thing will make you move is that your passion and your love for this idea and your belief in it. And that's the key, which makes a difference. Of course, Arun talked a lot about the lean startup and key tool which is used, which is the canvas. And whatever you're trying to solve, and you have to have some value proposition. That's a problem which you're solving for the customer. And you know very well which of our customer problems we're helping to solve. And then which customer needs are more satisfying. And once you know the value proposition, this is the value proposition, which is clear what the problem you're solving for the customer, then you can define who are the customer and the target customer which you're targeting. And so who are the most important customer and who is the biggest in this, and what job you're going to be doing for them, or your solution will be doing for them. Then once you define the customer, you know the value proposition, you define the customer, then you define how you're going to reach them, how you're going to reach this customer, and what kind of relationship you're going to build with them. And once you define this, now you can define what the source of revenue, how much revenue you're going to get, and in what form. Are you going to be subscription-based, or are you going to sell hardware, or are you going to sell software, or are you going to sell service, or all the combined? And the more you nest it, the more you can lock the customer as a loyal customer, and it will become hard for them to switch. Then you can go and then you can define the key activity you need to do in order to fulfill the customer need, and then the key resources that you require. I mean, in this case, you might require a software programmer, or we're not the expert in this, so we need to hire the expert to source it, and who is going to be your key partner. This other side here will give you all the cost element. So applying this is very iterative, and you use lots of yellow stickers and so on, and you put it with your team, and looking at it, changing it, and asking lots of questions in order to come to it. So this is how sort of entrepreneur find ideas and the problem to solve, and then how they choose it, and what make a difference. And of course, the attractiveness of idea will depend on if you're satisfying some customer need. So it's always come back to that there must be a customer pain that you satisfy, whether it's real or not real. Because sometimes we might imagine, but it's not really real. It has to be real. And then you have a medium or long-term potential for it to grow, and you have sufficient market, and you can spend little capital, not lots of capital to do it, and so on and so on, which these are all what factors determine attractiveness. And at the beginning, you don't have all the data. You don't have the data. But you can use this in comparison. If you have multiple ideas, you have so many in the bucket A, you can put them all, and then you can say high, low, in order to determine which among these ideas is the best. Okay, very good. Thank you very much, and I'll be happy to answer any questions.
Questions?
Okay. Can you elaborate more on market pull versus an unmet need in the market?
Yes, so a market pull is that, again, as Arun said, if there is if a pain exists. For example, in the United States, do you know how many people are still using Windows 95? Windows 95, still using it. Lots of small businesses operate with Windows 95, and it worked for them, and it's fine. They invested in it, and they're using it. It does the job for them in the United States. 10 million people are small businesses still using Windows 95. Now, these people, you think Microsoft is supporting them if they run into a problem or a glitch in the Windows 95 operating system? Nobody's helping them. So they have a pain. Right? If somebody says, oh yeah, there's 10 million people who are using Windows 95, I'm going to specialize to service these people, and I'm going to service them online as well. I'm going to help them solve the problem online. Now that's a market pull, because you identify a pain in the market and a large group of people who have it, and they are just dying in order to get somebody to help them. As long as, of course, it's not cheaper than the substitute. You know, switching to Windows 98, for example, which is still premature, and as long as you're providing it cheaper and more convenient than the switching alternative, then you have a pull from the marketplace. That's an example. Technology push is, lots of research and lots of large corporations. They have fantastic research and development people, and they keep, including Microsoft. Microsoft Windows 7 probably has so much stuff in it that nobody even knows or using today. That's a technology push. We are just changing it in order to and making it better, faster, and so on, but really whether we use all this or not, we're not sure. So that's a technology push. Of course, large companies have the capacity and the marketing muscle in order to convince you that you want it, for instance. So they push it all the time. Is that okay? Satisfy you?
Okay.
Okay, thank you.
Any more?
Hey, thank you.
Thank you, Doctor, for that wonderful presentation. While others see problems, entrepreneurs and business leaders see an opportunity. I don't know how many of you realize that Dr. Lotfi, while he started his presentation, he found that Harun had really covered almost everything. And so that was a problem, but he used that as an opportunity and related to his presentation and reinforced a lot of points, including finding a pain point and finding a solution, finding a problem solution fit, customer development, and then dwelled on the green canvas. Thank you, Doctor. Before we break for dinner, I had a request from one of the participants, Christina. She, in the last session, misplaced her engagement ring, which was pretty important to her. If anybody found it or knows about it, Christina, you ready? Kind of get in touch with her. We will have a dinner break now, and we will reassemble at 8 p.m. Please network and enjoy. Thank you. Eric is an executive and lawyer with a strong history of leading corporate development, strategic thinking, legal, risk management, and finance functions for various businesses. He has helped companies grow through strategic transactions and has successfully led more than 70 acquisitions, joint ventures, and other strategic transactions in 32 countries across 6 continents. Eric holds LLB from Israel Hall Law School and an MBA from York University Schulich School of Business. Eric is a charter member of Thai Toronto and a steady one of that. We look forward to an interesting session.
Thank you, Lloyd. Well, you've had dinner. Everybody's a little drowsy. So the organizers are counting on my charismatic personality and dynamic presentation to keep everyone alert. Of course, thoughts. Anyway. Okay. IP. It's a vast area, but it really boils down to being the secret sauce for a lot of businesses. It's a tool for differentiating your business from those of your competitors and for delivering value to your customers. Essentially, unlike a lot of things, it's completely intangible. It consists of inventions or expressions of ideas. Note that it does not, an idea itself is not within the realm of intellectual property that's used in business. But it needs to be novel. It needs to be proprietary. And initially, it's all secret. But a lot of it becomes or enters the public domain through registration or other use. Basically divides into 5 categories. Okay. Trade secrets, which are the stuff that you don't tell anybody. Two well-known examples are the formula for Coca-Cola, which sits in a bank vault in Atlanta, and of course KFC's secret blend of 11 herbs and spices or something, which have been in active use for many, many years, in the case of Coca-Cola over a century, without any form of public disclosure, without any form of registration. And a lot of companies, as a conscious strategy, prefer to go this route. Patents are probably the best known form of IP. Again, these are inventions. They can either be a process or method or way of doing something, or a device, or the way that something is put together. Industrial design is an offshoot of patents. We call it industrial design in Canada. In the US, it's called design patents. And again, it's essentially visual. Industrial designs are visual representations. The shape of something, how it's ornamented, the pattern that it uses. You think of Burberry, everybody thinks of that particular unique check pattern that they use. That would qualify as an industrial design, could also qualify as a trademark. And because again, trademarks include designs that you use to identify your business and differentiate it from others. And copyright is something a lot of people don't think much about, but it's another form of IP, and everybody, in fact, uses it because I think if you have a website, your website is covered by copyright, the contents of it. In any company, and startups are no different, there's a huge need to balance needs and resources. In IP, this is character, which can be very expensive to fully protect. You need to make hard decisions on what you're going to file by way of patent or trademark or other registrations, and when and where, and balance that against the cash you have available, which is always an extremely scarce resource, to do that. And you face issues regularly about what information to disclose and how to disclose it to people like your investors, your customers, key suppliers, sometimes regulators. And when you've done your registration, you're still not scot-free, because now it's up to you as a patent holder, trademark owner, whatever, to enforce your rights. Nobody does it for you. I've had the good fortune to have managed global IP portfolios, the bad fortune to have also, as a result, been responsible for managing complex patent litigation, and the worst fortune that was in the United States. And I can tell you that if you want to completely distract a company from its regular business and spend sums of money undreamed of, patent litigation in the US is a great way to do that. And for many companies, again, enforcement comes down to hard choices. You know, are you willing to spend the time and money it takes to protect what you spent time and money to register? You also need to play defense. You need to know what else is out there. Not only what you have, but what other people have that impacts the way you do business. So you need to be regularly searching patent and trademark databases that are in your field. And this, fortunately, can be done for free. Certainly in Canada and the US, patent and trademark databases are available online to anybody. And you need to make a point of doing that. The most basic form of intellectual property is a trade secret, something you know, it's critical in your business, that nobody else knows. And everything, every piece of IP starts this way. Long before you register anything, you conceive it, and you try to keep it secret. You have issues with this, both inside your company and outside. And internally, you need to put in place processes, controls, and communication channels that ensure that people who need to know, and people who don't need to know, don't. And that people understand the difference between what is sort of generic to our business that we talk to customers and others about, and what we know that we don't talk about outside the walls of our office. And this, a key element in accomplishing this is simply the employment agreements that you have with your people. And every employment agreement, no matter how short or how long, should have in it a clause that says anything you as the employee conceive or create during your employment that relates to the business of the employer belongs to the employer. Because in a lot of cases, things like patents and copyrightable materials are assumed to belong to the inventor or the author, unless they can be shown to be a work for hire. And you also need to have confidentiality clauses that obligate the employee to respect the confidentiality of your trade secret information and other confidential information. And even more than that, you need to be sure that people actually read and understand this thing. And it's surprising how many companies, present the form and say, "Oh, just sign here, George." And, we may send a copy to you so you know what you signed. And leave it at that. In dealing with outsiders, you need to have principles that around disclosure, so that you understand what it is you're telling people and what you're not going to tell people. This can be touchy when you're talking to people like potential investors who want to know everything about your business, including the things that you really don't want to tell them, at least until they put real money in the bank account. And one way to deal with this, and then, again, having been involved in the purchase and sale of a number of businesses, this is something that comes up regularly. It's okay to tell people, you can decide that it's okay to tell outsiders what it is the company has done in talking about products and technology. It's okay to talk about what the technology accomplishes, the result it delivers to the customer, and why that's a benefit to the customer. And it's also okay to say, but, how we do it, how that happens, is confidential, and we're not going to tell you. Harun made reference, somewhat derogatory reference, to confidentiality agreements. I was disappointed that his remarks were somewhat derogatory because I would go further. In the early part of my career, I was working for Canadian-based companies that did business around the world, and often in technology-related areas. And yes, we used confidentiality agreements with strategic partners, people we were doing joint research with, etc. They weren't terribly long, and they were pretty clearly written. And the reason for that was simple. If you want people to respect an agreement, they need to know what they've signed. And most importantly, you want to be sure that you're dealing with people and companies that will respect those types of agreements. In later years, during the dot boom, I started doing contract CFO work in Atlanta for technology startups. And since coming back to Toronto, I've been doing a lot of work with small medium enterprises. And it intrigues me how small businesses and startups basically fetishize confidentiality agreements. There's a sense that if it's long, it must be good. Nobody actually reads them. But they carry them around, as everyone said, in their briefcase, pull it out at every opportunity with everyone they talk to. So before I can talk to you about the weather, I need you to sign this NDA. The first thing to know about confidentiality agreements is that there is no standard form. Everybody talks about, oh yeah, they gave us their standard form of confidentiality. Long is not good. Often it's bad. The more you try to cram in, the more you risk leaving out. You're always better with simple, clear language rather than a long list of things that you say are confidential, many of which are in fact not at all confidential. Because one reason being, if you ever have to take this thing to court, a judge will not edit your contract. He thinks it's either good or bad. And if he sees things like the name of your company is confidential, the fact that your company exists is confidential, your sales brochure is confidential, the names of your directors are confidential, so this is all public information. You have no right to protect it, so I'm not going to let you. He's going to throw out the whole agreement. And then where are you? There is, when I got back to Toronto, there was a lot of people circulating some form that had International Chamber of Commerce on it as a confidentiality and non-circumvention agreement. And I actually read the thing, which most of them had not. Found it completely incomprehensible and completely ineffective. But there were, and still are, I saw another one about 2 months ago. Oh, here's the confidentiality agreement we were given. But so the thing is still kicking around. But it's evidence to me that nobody does actually read these things. And they should. You should know, in any contract, you should know what's in it, what you're obligating yourself to. But the most important thing, and again, if you do run into somebody who you think has stolen your secret sauce and you want to sue them to enforce it, well, lawsuits are complicated and they're expensive. And confidentiality agreements, by their very nature, are difficult to enforce because you really have to prove that the other guy would not have known anything about this unless you told it to him. Which is, again, you're having to enter into people's minds, which judges don't like. And just by the by, if you start a commercial lawsuit in Ontario today, you can expect that it will come to trial maybe in 3 years, more likely in 5. And ask yourself how much benefit you're going to receive at that point from whatever it is you're looking to get. So for a lot of companies, especially in the technology area, patents are the lifeblood. If you've got an idea that you think, or product or method that you think should be patented, you got decisions to make. The first decision you have to make is whether you want to file a Canadian patent application or what's called a PCT application. PCT stands for Patent Cooperation Treaty, and it's an agreement amongst a great many countries to set up an international regime for registering patents. And typically, it's obviously less expensive to file just a Canadian application, but you do have to ask yourself, if this is such a great idea, what good is it to me only protect it in Canada and not in other markets like the US, like Europe, like Asia? So my recommendation would always be that a PCT application is the better mousetrap, because you get priority rights when you bring that into other countries. And priority is important because almost every country in the world governs patent eligibility on who filed first. So if George brings an application for a new form of widget in on Monday at 2 o'clock, and Jane, who actually invented it earlier, files a competing application at 11 o'clock the next morning, Jane's out of luck. She got beat to the door. And that first to file, that filing date priority in a PCT application goes back, wherever you file it, goes back to your first application, whether that's in Canada or elsewhere. If you plan on looking at patent protection for any of your products, you need to make sure you have an appropriate corporate process to assign the rights to those patents, to those ideas, from the individuals within your company to the company itself, which is quite permissible. But you have to have it in their employment contracts, as I mentioned earlier. You also need to bite the bullet that you're going to need professional help. You're going to need a patent agent or somebody like that to actually write the patent application for you. Because I can guarantee you, you don't know how to do it. I don't know how to do it. Patent agents, that's about all they know, and they're, for the most part, very good at it, and they should be the people doing it. What you apply for in a patent is a very interesting question. What scope do you want to put around it? And here a little history is appropriate. From early days through the late 60s, early 70s, patent offices were firmly of the view that they were giving out some rare and special privilege, and that it should only go to people who clearly demonstrated that they were entitled to this august award, and that even then it should be restricted to as narrow a field as possible. And the reason for this is that a patent is a monopoly. It's an exclusive right to make and sell something that nobody else can. So it precludes competition. Throughout most of the 20th century, the bias in government policy, public policy, was to promote competition and discourage monopolies and oligopolies. And the patent offices played their role. Then came the late 60s, early 70s, and Japanese companies took over or gained strong positions in all sorts of manufacturing-based industries in North America. And North American societies and governments said, whoops, this is bad. We have to encourage innovation. And why is it that Canadian and US companies are so bad at filing for patents compared to Japanese companies? The Patent Office heard that in both countries, and they started granting more patents and broader claims. And along with that, the deluge of new applications has overwhelmed the staff, certainly in the USPTO, where there were times when if you filed an application in a tech-related area, it would literally disappear for 2 to 3 years before anybody looked at it, because nobody had the time. The patent examiners, when it's assigned, are entitled to do independent research. In the US, unlike in Canada, applicants are required to disclose all prior art that they're aware of in their application. So the examiner is therefore, can be of the view that, well, if they've disclosed all the prior art, I don't need to do my own search, and by the way, I'm overworked. And also, little known secret, patent examiners are, of course, subject to performance reviews. And a key element of their performance review is how many cases did they resolve? How many files got totally cleared under their watch in the previous year? And you don't have to be a rocket scientist to figure out that you won't clear cases by challenging a lot of claims and applications. So if in doubt, let it go by. So you find that through the 80s and 90s and into the 21st century, companies are getting much broader claims than in the past, and this is stymieing competitors. And you can look at some of the high-profile pieces of patent litigation to see this. And therefore, if you are applying for a patent, you want to make sure that you have as many claims in it as you can make, and that those claims are as broad as they can be, maybe broader than they should. The examiner may challenge a few, he may let some through, but you won't get more than you ask for, so it's a strategy to say, let's go for more than we should get. Patent applications are now in every country except the US, and that's changing there, published about 18 months after they're first filed. This is a notice to the world that Joe Bloggs has applied for this patent on that technology. It is not necessarily, it depends on local law. In Canada, that does not entitle someone to challenge the application or intervene in the process. That's between the applicant and the patent office. But it does serve as notice to the world that this is coming. And again, if you're in a business that is technology related, you want to be following publication pending applications in your area. To get a patent, we got to meet three basic criteria. Your technology has to be novel, that is new. It has to be useful. Although there are a lot of patents that have been issued that you might look at and say, who the heck would ever do anything with this? And it can't be obvious. So if somebody's made a gizmo with a mechanical on-off switch, and you think, well, you could easily put an electronic on-off switch on that. That could be challenged as being obvious, that it's a person skilled in the art would understand that you can do this, so it's not necessarily anything great or new. The other thing to be wary of is you want to protect what customers value, not what your researcher thinks is cool. In one of the complex patent suits that I made reference to, we were the defendant, which is never a happy place to be, because courts revere patents, and they actually think that they have been subject to close scrutiny by the patent office, whether or not that's true. But we were fortunate because the value that the product delivered to the customer was that in an industry that was plagued by health and safety issues, it made the use of a highly dangerous product a lot safer. But they didn't patent that feature. They patented the composition of what was in the package. Not the package, and not the way it was delivered. So for our company, it was a case of we can avoid this by copying the package and the delivery means and just putting a different form of product inside the package. And we did that. And that sort of took the whole thing offside. But at the competitor, the researchers were in love with this way that they had cast a solid detergent into their container, and totally lost sight of the fact that the customer doesn't care what's in the container. It could be pixie dust for all of us. But if he can deliver it cost effectively, and he doesn't get injury claims from minimum wage workers who are not prone to follow safety procedures, then he's getting a great benefit. If you do file a PCT claim, the Canadian Patent Office very helpfully provides you with this simple overview of the process, which basically comes down to you're going to file first in a country that's a member of the PCT, and Canada is. That it's going to be you're going to do a search through an international searching authority. You're going to take the application. You're going to designate countries that you want to take the application to, and you've got a period of time within which to do that. It's significantly more expensive than filing a claim in Canada alone, but it will grant you protection in all sorts of markets that otherwise would be shut out. Patent law is pretty similar across the world thanks to some international treaties. The big exception is the US, which for a variety of political reasons held on to its own way of doing things until just last year, when the Congress passed and the President signed the American Defense Act, which is the first significant changed the US patent law in 60 years. And under that, the US will transition from first to invent to first to file priority. So previously in the US, if George filed his application on the Monday and Jane filed hers on the Tuesday, Jane could argue that in fact, she was the first to invent it, so she should have the patent. In a first to file system, when she invented it doesn't matter. And that's primarily makes life a lot easier for patent offices to discern who should have a patent and who shouldn't. The Americans, of course, can't quite do what everybody else does, so they have a slightly different system called first inventor to file. There are some detailed differences between that and the more conventional international form of first to file, but I won't go into this here. And that will take effect in 2013, March. There are three other items that you might want to pay some attention to in the US. There is this thing called the business method patent that has been identified in US law, and it's been identified because Congress has decided they don't like it. So the American Invents Act also requires that the US Patent and Trademark Office set up a special post-grant review process for certain types of business method patents that will make it easy to challenge them. And a business method patent is simply a way of performing some particular operation in the practice or management of a financial product or service. It's a bit arcane. As I mentioned earlier, what we call industrial design, the US calls a design patent. Different terminology, but it means the same thing. And the other thing to be aware of in the US is the prevalence since the mid-90s of software patents.
Sorry, Eric, could you give us some more examples of business method patents?
Yeah, there were companies where Congress got involved was because there were companies that developed financial analytical tools that they wanted to sell to banks and trust companies and others. And in order to enhance their own business, they patented these tools. And they're essentially ways of formats, methodologies for analyzing some particular financial product, service, or issue. And then, of course, they go around to the banks and others and say, for a fee, we'll let you use this. And the bank may say, we shouldn't have to pay you to do this because folks do it, on the back of an envelope or on a computer, they do something similar. And then they find themselves sued for infringement. There are other forms of method patents that have been controversial. Amazon.com, many years ago, patented this notion of one-click buying on an internet site. And, a lot of people, especially people who were selling via the internet, thought there wasn't really much novel about that. So method patents are always a little, can be controversial. Software patents are patents on software programs. And the US, for some reason, allows much more latitude in patenting software than most other countries do. Not so much as a matter of law, but practice. And as a result, companies have been sued because if somebody's gone into their software and tried to figure out, like with RIM, for example, that the software infringes a patent that's issued. In industrial design, I won't spend too much time on it. It's basically, as I said, a shape, pattern, or ornamentation. If you acquire an industrial design, your coverage is only for 10 years, and you can't renew it. So most people would prefer to do something like that as a trademark. And you can think of things that say like the Burberry plaid design or the shape of the classic Coca-Cola bottle as something that could be either an industrial design or a trademark, but you'd much rather have it as a trademark. Because the trademark registration can be renewed forever as long as you're using it. And you don't have to register trademarks. The chief benefit is that you can only protect it based on use, And when you file for a trademark, the date you file for it is deemed to be the date of first use. So it establishes a public record in case there's any litigation or controversy over it, that you've been using the mark since this date. And again, trademark is something, you know, even in a small company, you might want to register the you know, one or two or three that you consider critical. Things that aren't critical, you know, you've got common law rights if you need them. So you might want to save yourself the cost of registration. Copyright, again, is any kind of literary or artistic work. In businesses, you'd look at things like your website, product manuals, brochures, what have you. You probably wouldn't register it in most cases. It's really just a registration is simply a notice to the world that, you know, you claim this is copyrighted. It establishes a record of what the copyrighted material consists of. And by the way, if somebody wants to license it and it's registered, they can see from the registration who the owner is and contact them. But the key, the IP is no different than any other element of your business. You need a strategy for dealing with it. You need to be able to decide how important it is to you and what is important within that. First priority is always, you know, if you don't have to disclose it, don't. Keep it secret. If it's secret, you don't have to worry about people infringing it. But more than that, in every company, and I can tell you whether it's, you know, a multinational or a startup, you need to set your priorities. You've got limited resources, and I can tell you from budget fights I've had in previous companies that even in very large companies, the cost of protecting IP can be difficult for companies to want to swallow when they don't necessarily see that as something that adds directly to the bottom line. So you need to balance the need you have to protect stuff that's critical against the resources you have to do that. And to understand what rights IP protection gives you and what its limitations are. And within that, you also need to understand the larger context of what you're up against. And that means, as I mentioned earlier, continually looking at what other people are protecting that might limit your ability to do business in your industry, in your area. So, again, it's a vast area. There's no, you know, simple, here's what to do list that applies to everybody. Every company's situation is different, every industry is different. You need to focus on understanding what is important to your company and your business and your needs.
Questions? So many.
Just to let you know, there's a fire alarm investigation going on. We are on hold. And if there's anything that is learned, we'll have to vacate the place pretty quickly, but we're okay for now.
All right. I just wanted to know how you would apply this to the arts. So dance, art, any business that's in the arts.
Oh, okay. Well, firstly, the arts are much more concerned with copyright than are other industries. The first stop in my business career was Harlequin Enterprises, who were in the publishing business. And IP there was simply a straightforward focus on copyright and trademarks. We did not register copyrights. We did register trademarks. In the US, if you want to sue to protect a copyright interest, you have to first register it. But you can do that at the time. So, again, you need to, and you're also probably involved in licensing. If you want to put on a performance of somebody else's work, you need to have the right to do that. If you want to play their music at a gallery, that needs to be licensed. So these things do come into play, but it's a narrower focus, certainly. Yep.
Hi, I apologise if this is too specific, but I wondered, can you patent software that that includes as a key component somebody else's patented IP?
Well, the answer to that is more general. If Alexander Graham Bell patented the telephone. Now, a lot of people patented improvements to the telephone over the years. And you can certainly patent improvements to a previously patented technology. And which is very common, extremely common. The difficulty is that does not give you the right to use the core that is patented by somebody else without their permission. But as a business strategy, a lot of times, if a competitor has patented something that is quite useful in the business, a competing company might look to see what they could patent around that as an improvement that they could use to maybe trade off. We'll license you ours if you'll license us yours. And that sort of sharing, if you will, is very common in some industries, including the technology industry. Yes?
I have a question about industrial design patents versus trademarks. I'm an industrial designer by trade, and I have an industrial design registration on a product I'm looking to take to market. I didn't realize actually that it would expire after 10 years without renewal. I have to renew it after 5, I think, and then
Yes.
is that something that I can then turn into a trademark if it's a
Yeah, well,
build the product?
they're not mutually exclusive. You could, and oftentimes, let's talk about, say, a green lamp. Okay, you might design a particular type of green lamp that you think will be very popular, and register that as an industrial design so people won't copy you. If it's successful, you may take that shade as the logo for your company and use it as a trademark.
But would that protect it as a product? That's my question.
By and large, yes. I mean, you don't see people copying the Coca-Cola bottle because Coca-Cola would be all over it. That the shape of that bottle is a trademark identified with the Coca-Cola company. And it's the same thing when Steve Jobs and his friends established Apple. One of their first orders of business was to fend off an infringement claim from Apple Music, the Beatles company. And they spent about 2 years coming to an agreement on how Apple Computer would be differentiated from Apple Music, and including, and most especially, the Apple design that each company used.
So can three-dimensional objects be trademarked, or is it the 2D representation of that?
I see no again. The classic Coca-Cola bottle is a three-dimensional object, and it may be represented in 2 dimensions, in a product brochure, but it is actually designed to be used and marketed as a trademark for the company. And actually, if you follow the litigation between Apple and Samsung, a key component of Apple's case is that Samsung and some of their phones have mimicked the look and feel of the iPhone. That the black device, rounded corners, big screen. And even though, Samsung put Samsung in big letters on it versus Apple's little wee Apple design, a jury in Santa Clara decided that constituted an infringement, and levied a fine of damages, of $1 billion against Samsung. Now, it remains to be seen if that'll stand up on appeal. cynic would say that you would expect a jury in Silicon Valley to decide for Apple against a Korean company. But, you know, that's whatever. But again, yeah, three-dimensional object, sure. Sure, if it's a unique representation of your business.
More questions?
Could I get your opinion on what one would expect to pay for a patent? Because I've received prices from like